Lucia? Going okay? Following. No distractions. Are we missing our partners, your neighbors? Still waiting for a few people. Okay. Okay, everyone. I think we should continue then. Before we delve into novelty, are there any questions on anything that we touched on earlier today? Okay, if not, did you have a good lunch? Everyone awake, revitalized, energized? Hope so. There's still quite a lot of ground that we need to cover in the next 2 days. I know it's information overload, but we have to get through this. So if you feel that my pace picks up, just let me know if you get lost along the way so that we can just regroup and I can just check in on how we're progressing. In terms of access to Bowles Bridge, I know some people didn't have issues, some people had issues. Is everyone okay? Well, you are, yeah, but did you have difficulties getting in? Okay, not. All right. Okay, so hopefully tomorrow there won't be any hiccups as well. I'll try and organize access codes for everyone from IT, but it is a bit of a difficult situation because I have to generate one by one for each person. But let's see. Okay, so let's go into novelty. So we know the extrinsic requirements of patentability, novelty, inventiveness, and utility. Okay, you're going to be saying that when I come ask you in your sleep, what are the extrinsic requirements, right? Because we've touched on those words and concepts so many times. But what is novelty? Sorry, I just need to admit some attendees. In terms of section 25.5, an invention shall be deemed to be new, so it will have novelty, if it does not form part of the state of the art immediately before the priority date of that application. So an invention must be new before its priority date. So that's why the priority date is so important, because the novelty is assessed from that date. So anything before that date will count as prior art, will count as something that has existed in the public domain. Anything after that will not be novelty destroying, because you have the filing date in respect of that invention. Okay, so that is why your priority date is so important. An invention is deemed to be new if it does not form part of the prior art immediately before the priority date of that invention. So I think we all know what the priority date is now. The priority date is the filing date of the first application in respect of that invention. Okay, so it's the first application that was lodged in respect of the invention, whether it's in another country or whether it was first filed in South Africa, doesn't matter, but the first filing date in respect of that invention is the priority date. But now section 25 tells us that it must not form part of the state of the art. So what is the state of the art? Section 25.6 tells us exactly what the state of the art is. It says that the state of the art shall comprise all matter, whether it's a product, a process, information about either or anything which has been made available to the public, whether in South Africa or any other country in the world, by written or oral description, by use or in any other way. So it's basically every disclosure, whether it was written, whether it was prophesied, spoken about. So me presenting to you in front, if I was disclosing my invention to you, that would likely be considered novelty destroying if this was not a closed meeting, or there was some non-disclosure agreement that we entered into to protect the disclosure that is made. So we know that anything counts as prior art, can be oral disclosure, so lecture or presentation, written publication, so whether it's a book, a journal article, other patents, sometimes patent applications, anything that was broadcast on TV, movies. There's even talks about Star Wars was so advanced at the time that those movies were made that some of the things that were filmed and thought of in there were considered prior art in other patent applications. Whether there's truth to that or not, I don't know. Prior use by carrying out a method or manufacture of a sale or an article. So that comes down to whether there's commercial use of a product. Disclosure on a website. This one happens quite commonly. I had a case not related to patents, but where a client of mine wanted to protect the shape and configuration, so the design of one of these medicated patches. So, like a Transact plaster. They had erroneously published the brochure of that product on their website. It was in the public domain, and they had missed the grace period for designs. So this arises quite often in practice. The disclosure must have been made available to the public. There is case law on what defines what is available to the public, but it is more specific to a person that would understand it. So if it is amongst peers, so if you're at a university, you're exhibiting amongst your colleagues, that is more likely to be considered a disclosure to public, so someone that will actually understand what that disclosure is. And we know that it can be anywhere in the world. It's not confined to South Africa only. So if the disclosure was made in another country, that will also form part of the prior art. Yes.
Let's say someone is attending work at an institution. Outside of the work hasn't went anywhere. How would anyone say try to search know that the person is under the work?
It should come down to people testifying against it to say that this is something that was disclosed at this exhibition. I mean, you'd have to prove that there was disclosure of it if you're trying to invalidate the patent based on novelty.
So the person invention can get away with it if nobody.
Yeah. So the onus is on that party that alleges to prove that allegation, to show that there was a disclosure. So maybe they were recording the presentation, something like that, that they've got evidence that there was a disclosure. Okay, but there are some exceptions to novelty. Yes. That won't be so. The question is if there is a disclosure in a scientific publication, for instance, and not the essential integers are disclosed, whether that is still novelty destroying. It wouldn't. And there is case law on this as well that says that the disclosure that was made must be an enabling disclosure. So it must be able to enable somebody to actually put into practice that invention. Okay. And remember, if those essential integers are what provide the novelty and that wasn't disclosed, then the novelty hasn't been destroyed because there was no disclosure of that novel feature. Okay. So there are some exceptions to novelty in terms of the Act. And I've categorized these into two scenarios. The first one is where there isn't any disclosure, there's no public disclosure of the invention, but it is still considered novelty destroying. The first one is in terms of section 25(7), where there's a prior patent application. So this is again a section that has quite a bit of a mouthful, but let's go through the wording. It says the state of the art shall also comprise matter contained in an application open to public inspection for a patent, notwithstanding that the application was lodged at the patent office and became open to public inspection on or after the priority dates of the relevant invention. If that matter was contained in that application, both as lodged and as open to public inspection, and the priority date of that matter is earlier than that of the invention. Okay, who wants to explain? No takers. Okay, so I said it is quite a mouthful. What section 25(7) tells us is that if you file a patent application and there was already an application filed for that same invention, say that is the case, that happens, where it's the same invention. I filed my application today for the protection of that invention, but somebody else filed an application for the same invention last week. I wasn't aware of that application that was filed because it's not open to public inspection yet. So it isn't public knowledge that that application contains the same invention as mine. That invention will still be considered novelty destroying against my application that was filed today if the earlier filed application becomes open to public inspection. So if it proceeds to grant. So even though I, as an applicant, have bona fide filed an application for my invention, and somebody else also filed an application for the same invention before mine, and I'm unaware of it because it's not open to public inspection, it will still destroy the novelty of my application once it becomes open to public inspection. Okay, that's the crux of what section 25(7) tells us. If the prior filed application doesn't proceed to grant or it doesn't meet the timeline where it becomes open to public inspection, then it doesn't destroy the novelty. Okay, so that's the requirement in order for it to destroy novelty. It has to become open to public inspection. All right. So it depends on the type of application that we file. So we'll touch on that. So let's not delve too much into that, but we will touch on it. Okay. Then secondly, which we spoke about earlier, secret commercial use, where there's a trade secret. This is specific to trade secrets, section 25(8). An invention used secretly and on a commercial scale within the Republic of South Africa shall be deemed to form part of the state of the art for the purposes of subsection 5. So if there's a trade secret that is being used on a commercial scale within South Africa, it will count as prior art against my invention in South Africa.
No, if it is allowed now, let's say you discovered the same thing as the trade secret, can you improve on it and then
Yeah. You can. So any improvement, even if it was a trade secret, you can protect that. Okay, another question? The P&E document. What's the P&E document? Oh, the search report. It doesn't really relate to the search reports. It relates to there being a co-pending application that was filed. So whether it was examined or not doesn't matter. Okay. Another question at the back? So the question is, okay, so the question is if beta testing will destroy novelty. So there are certain instances where it won't, and that is more specifically to clinical trials and conducting research. So where a research institute needs to actually use that invention in order to conduct their research, then it is not considered novelty destroying, but only in those instances. Yes, okay.
This trademark would be mentioning a patent search. I was wondering if that is like a patent search similar to what we would conduct for a trademark. So are you? Okay.
Okay. Okay, so now we've addressed the instances where there's no disclosure, but it destroys a novelty. Now we're looking at the inverse, where there is disclosure of the invention, but it is not novelty destroying. So section 25(9), which we've gone through to quite an extent, we've discussed it at length. So that's for second medical use. So where a known compound is used for second medical use, it does not invalidate the rights because of a lack of novelty. When the projector's tired. Sorry, online team, we have a technical issue again with the projector. Yeah, no, it's good. Hi guys, the team online, can you just give me a thumbs up if you can hear me now? If there's audio. Okay, perfect. Thanks a lot. Thanks, guys. Sorry for that. I hope this is the last gremlin that you experienced today. Okay, so now we know where there is an unauthorized disclosure and you seek to obtain patent protection that the novelty won't be destroyed. Then another exception is where the invention is being worked in South Africa by way of a reasonable technical trial or experiment by the applicant or patentee or the predecessor in title. Okay, so where there is a technical trial. So this would be in the instance where you are trying to get your pharmaceutical onto the market and you need to conduct clinical trials as an example, or where you're working at a research institution and you are conducting trials at the research institution in order to meet certain standards or regulatory approvals.
Any trials outside of South Africa?
Yeah, so trials, technical trials outside. So this is confined to the borders of South Africa. And then was there a question online? Okay, so how do the courts determine whether an invention is novel or not? Now, there's a three-part test that was set out in the Gentiruco versus Firestone case. This is a very lengthy judgment, but it is a very important judgment, and you need to know this case and you need to know the citations. I don't expect you to read through the entire judgment or even to provide me the facts. I just want to know what the three-step test was that was set out in the Gentiruco versus Firestone case. So the first step that needs to be taken in order to determine whether an invention is novel is that the claims of the patent have to be construed. So remember I said the claims define the scope of protection. That is where the monopoly exists. It is what you set out to protect is within the claims of the specification. So the court needs to have a look at what those claims are. And it goes back to that shopping list that I spoke to you about earlier, where we have a receptacle, it's a vacuum flask, it has a cap. Each of those are individual integers. Okay, the individual features that make up this invention. And that's essentially what the court will do. They'll look at those claims and break it down into its elements. They'll break it into a receptacle, that it's vacuumed, that it's made of aluminium, if those are what the claim said, that it has a thread, has a cap. That would form part of the integers, and that is the way that those claims would be broken down. Then they would need to look at the prior art. So what is being presented to the court as prior art that a party is alleging destroys the novelty of this invention? And they would need to see in that single prior art document, it can only be one prior art that you can use at a time to determine novelty. Do all of these integers exist within that prior disclosure? So that's why I say it's very objective. It's either it's present or it's not present in the prior art. If all of these integers are disclosed in that document, then it lacks novelty. Okay, then it's not considered a new invention because all of this was previously disclosed in one prior art document. And that is the comparison then, what the courts would do. All right. So pretty straightforward test. You construe the claims into their integers, you consider what the prior art is, and you compare the two to see whether all of the integers of the invention are disclosed in the prior art. And when I say it's not possible to mosaic several prior art documents, it means you can't take multiple sources, you can't take multiple documents and combine them and say, well, the lid is disclosed in that document, the flask base or receptacle is disclosed in another document, because that's not what those documents were disclosing. It has to be one piece of prior art that discloses and teaches that invention. Okay, so that brings us to the end of novelty. Then we move on to inventiveness, which is defined in section 2510. It says an invention shall be deemed to involve an inventive step if it is not obvious to a person skilled in the art, having regard to any matter which forms immediately before the priority dates of the invention, part of the state of the art. Okay, so it must involve an inventive step, and it does involve an inventive step if it is not obvious to a person that is skilled in the art. So again, this is the subjective consideration when it comes to the patentability requirements, because how do you make that assessment on whether something is inventive? It has to be in the shoes of somebody that is skilled in that technology, that is skilled in that state of the art, in order to determine whether they would have found it to be something obvious to them or not. And this is where I mentioned earlier this morning, is where the courts will rely on the opinions of expert witnesses to testify whether they deem something to be inventive or not. In order to look at inventiveness, though, the courts may consider multiple prior art documents. So they can actually mosaic documents and consider all sources of prior art to see whether, by that combination, whether it would have been inventive. The thing is, when it comes to assessing inventiveness, the state of the art does not include those prior applications or trade secrets. Okay. So it's only something that is publicly available that is considered when determining inventiveness. So a pending application that was filed before my application that's not open to public inspection, or where it's a trade secret that's used commercially, is not used to determine inventiveness. So again, another test, how the courts determine inventiveness, which was set out in the Ensign Bickford case versus AECI Explosives and Chemicals. This was an SCA judgment. And the test was, well, what is it that you are determining states in claiming to be inventive? So what is the inventive step said to be involved in the patent? What is it that you are claiming to be inventive? Then you would need to consider what was the state of the art. So what prior art was relevant to that invention prior to the priority date? And how does this step go beyond or differ from the state of the art? So how does the inventiveness or this invention differ and go beyond what was already known in the prior art? And then lastly, and most importantly, which is provided for in the Act, is would taking that step be obvious to a person skilled in the art? Then the utility requirement must be capable of being used. There's not really much for me to discuss here. It's just that the invention must be capable of being used, that it's not merely an idea. You can actually put it into practice. That's a question of fact as to whether something is capable of being used. So I have a video that I want to play to you. The only problem is that the audio is not working properly. So we can attempt, if we're very quiet, to see if we can hear it from the laptop. Otherwise, we'll just pass through it. But it's a very nice clip to show to you. This is taken from the movie A Flash of Genius. I don't know, has anyone here watched the movie Flash of Genius? No. Kind of IP lawyers. Yeah, no, just joking. This movie is based on a true story of a man named Robert Kearns. Now, Robert Kearns, on the night of his wedding, was ambitious in popping the champagne. And when he popped that cork, it shot into his eye. Okay. And he had struggled. It had damaged the nerve, and he had struggled with his vision from that night. The wedding's obviously not off to a great start. And particularly, he had difficulty when driving in the rain because his eyes could not distinguish this consistent rainfall. You know, he wasn't able to see through there. It made it very difficult for him to see. So he went into his basement and tried to come up with something to assist him when driving so that he's not a hazard on the roads. And he developed what is today known as the intermittent wiper blade. So there was a wiper blade at the time. And this was what the problem was that he was experiencing, was that the movement of the wiper blade was continuous. And it wasn't syncing with the blinking of the eye. And that's what the intermittent wiper blade does. It tries to eliminate that viewing of the wiper blade when you blink, if that makes sense, so that it kind of synchronizes with when the wiper blade moves. So he developed the intermittent wiper blade where you can adjust the speed of the wiper blade. So Robert Kearns thought, well, this is fantastic. I've developed this product. Let me see who can invest in this, possibly buy it from me. So he approached Ford Motor Company in the States. And they were very ambitious about this project. They were happy to take us on. Eventually, things fell through. The deal didn't go through. Sometime down the line, he goes to see the motor show. I think it was the Detroit Motor Show. And there, Ford, on display, had their new Mustang. And one of the selling features of the Ford Mustang was this intermittent variable wiper blade. Okay? So, you see, you've got big corporation taking the small man's idea and using it as their own. So he eventually decided to take Ford to court. All right. They tried to settle with him, but he didn't want to settle out of court. He wanted to prove a point that they stole it from him, and eventually got a lot less money out than what he would have had he settled. But for him, it was more about the fact of the infringement and the stealing of his rights, and that he was the rightful creator, the inventor of that invention. So let's see if we can hear this. I'm hoping we can. Otherwise, we'll just have to pass through it. Yeah. For those that didn't hear, I see the online participants had issues with the sound on their side. So they were arguing that everything that Kearns had put together to create his invention are parts that already existed. These things were all already disclosed. And they were saying, well, there's no novelty because all of those parts existed. So then he brought the Charles Dickens's Tales of Two Cities, and he started reading it, and he said, well, there's this word. Is this a new word? No, it's in the dictionary. And he moved on through the book with the different words, and all of those words had already existed. They're not new words, but the compilation of those words, the manner in which they're arranged, has created a famous novel. Okay, and that speaks to inventions too. Okay, we're touching on the novelty. These things may exist, but the order in which they are put together as a whole in totality may be something new. Okay, and that's what I wanted to demonstrate with this video clip. So that brings us then to the end of the patentability requirements. So let's just take a moment for questions then before we move on to procedure. So let's go to the gentleman.
Just for the native state, let's say that you can take multiple different
Prior art.
prior marks out of one
Yeah.
thing. So for that expert speaking like, would it have an issue with competing inventiveness?
So-
Prior art, all of those other things.
Yeah. So the question is that whether you can mosaic prior art for inventiveness, and you can look at different technologies, or not technologies, but different disclosures related that are relevant to that technology in order to determine it. It still comes down to, is it obvious to a person skilled in that art? So would somebody that is a technician or a developer of wiper technology, for lack of a better word, would it have been obvious to them to create something that is intermittent or not? And that's where the test lies. Is it obvious to somebody skilled? Okay, so it's not as easy as novelty, where you can exactly see this is present or it's not present. Okay. Any other questions before we move on? Let's just check online. Okay, we seem to be good there. I know it is getting late and everyone is probably getting tired. My voice is also starting to go, but we do need to move on. Otherwise, we won't finish within the 2 days. And this is probably, as I mentioned this earlier, not the most riveting part of the work, but it is very important. The way in which I generally question on the procedural aspects is to look specifically at timelines, deadlines. What I've done in the past is to give you the details of a patent with the different filing dates, what the priority date is, when that application was filed locally, whether it's a national phase application or a Paris Convention application. So I give you some information, and then from there, I would ask you questions as to when would the renewal fees be payable on this application? When was the deadline by which to file the South African application? What extensions are possible? So very much focused on these timelines, and we will deal with that when we work through the examination papers with some examples. Okay. So we're going to look at complete patent applications. Now, when I refer to a complete patent application, it's an application where you get granted rights that are either filed as the first instance in South Africa, claim South African priority, or it is filed by the Paris Convention. So where you're claiming priority from another country and you're filing it at the South African Patent Office within 12 months. That's what I refer to when I say a complete patent application. A national phase patent application refers to a patent application that is filed after following the PCT route. Okay, so there's a distinction between these two, and the dates and timelines do differ slightly amongst these two options. So we have to have this distinction between complete patent applications and national phase applications. So you have an inventor that comes and consults with you. They want to protect their invention. You advise them to file a provisional application. I'm throwing in another application amongst complete and national phase applications. A provisional application is exactly that. It's provisionally granting you a date to file an application. So you're filing this application. The difference between a provisional application and a complete application primarily is that a provisional application does not need to include the claims. You're just putting in a description of what the invention is so that you can secure that filing date from which novelty and inventiveness will be assessed. So you want to make sure that your application is in so that nobody else beats you to that invention, to have the rights over that invention. So you will file, and you don't have to do this. It is advisable in some instances. Sometimes it's not. You file a provisional application. A provisional application does not give you granted rights. You cannot enforce that. So a lot of people that advertise their products online or on the radio will say, we have a patent pending on this product. When I go and have a look on the patent register, they're like, actually, you've got nothing. You've got a provisional application. You don't have any rights. You've got the filing dates from which novelty and inventiveness is assessed. But the 12 months has already passed by which to complete it. So they actually have nothing at that point. So provisional application only secures your priority date. What it allows you to do is to buy you some time. So you've got 12 months within which to then file your complete application. Okay? Only once you file your complete application do you have something that can give you enforceable rights once it's granted. Provisional application never goes to grant. It never goes to acceptance. Okay? It's the complete application that does. So from filing your provisional application, you have 12 months within which to file your complete application. Now, in this scenario, we are looking at a South African provisional application and a South African complete application. In terms of the Patents Act, you have 12 months. This is not even looking at Paris Convention. You have 12 months in terms of the Patent Act to file your complete from a South African provisional application. You also are able to extend that 12-month period to 15 months. Okay, so the legislature was generous. They said, well, if you miss your 12 months, here's another 3 months mahala. You can still file your complete application. But remember that this is only applicable where it is a South African provisional and a South African complete. So say, for instance, the provisional that you are claiming priority from was filed in the United States. You do not have this benefit of a 3-month extension. It's not applicable in that instance. Okay. It's only where it's a South African provisional that you're claiming priority from. So most of you will know that the South African Patent Office does not substantively examine patent applications. Now, what do I mean by that? So where examination takes place, as example, in the international phase or in other examining jurisdictions, South Africa does not look at the patentability requirements, whether that invention filed in South Africa meets those requirements. So they don't check whether it is novel, they don't check whether it is inventive. They undertake formal examination to ensure that all the formal requirements are complied with. So whether all the documents that are required have been submitted. The onus is not on the patent office to ensure the validity of the patents on the register. It is on the applicant themselves to ensure that their patent is in a valid form. Okay? And we'll come to this when we look at the supporting documents. But within 18 months of filing your complete application, your application needs to be in order for acceptance. What I mean by that is that you must have complied with all the formal requirements that are stipulated in the Act and the regulations. So have you lodged your declarations that are necessary? Have you lodged the proof of the applicant's entitlement? Are they actually able to file that application? Do they have the rights to that invention or not? You need to submit those documents. And that all needs to be in order within 18 months. Those deadlines are extendable. The first 3 months is given to you as of right, so you are entitled to it. Any further extension, you need to provide good cause. So you need to, in your request to the Patent Office, stipulate why it is that you are looking for this extension. Now, South African applicants, and when I say South African applicants, I mean people that have filed applications in South Africa, not necessarily South Africans. What they will do is they will file applications all across the world where they want to protect the invention. But because South Africa doesn't examine the application substantively, they rather delay the South African application proceeding to grant to await the outcome of a corresponding application where it is being examined. So say there's the same invention, they're protecting it in South Africa and they're protecting it in Japan. Japan examines the application, right? They issue a written opinion and the client might want to amend it in order to overcome any objections. To ensure that this was examined, the examiner found this to be valid or not. And how do I overcome any objection to ensure that it is valid? So they delay the acceptance of the South African application in order to amend it once they have the outcome of examination in other countries. Now with everyone. Okay, so we now know that it is possible. For those that aren't aware, South Africa is introducing substantive examination, hopefully pretty soon. Okay. Once the formal examination has been undertaken by the Patent Office to ensure that everything in terms of the formal requirements have been met, they will issue you with an acceptance notice. So the Patent Office issues the acceptance notice, which is basically their stamp of approval to say that the application is in order and it can proceed to grant. Once the acceptance notice is issued, you have to publish the acceptance of the application in the Patent Journal within 3 months from the date of acceptance. And this is a very important deadline. If you miss that 3-month deadline within which to publish acceptance in the Patent Journal, the applicant loses their rights. Okay. So imagine all of the research and that is taken place, all the money expended in developing this technology, all the application fees that were filed, the attorney's fees. You get to the final step and you miss that 3-month deadline. You've got no protection in South Africa. Okay. So a very, very important deadline. Must be published within 3 months. You can request an extension of time within which to publish. There's conflicting judgments on this. There are 2 cases that deal with this. Okay, there's the University of Pretoria case versus the Registrar of Patents, and there's also the Mu Mechanicos case, which we'll touch on as we go on to acceptance a bit later on. But just know that this deadline is critical to ensuring that you don't have a loss of rights. Once the acceptance is published in the Patent Journal, the patent is granted and you have your enforceable rights. Your monopoly, your 20 years, is calculated from the South African complete filing date, not the provisional date. Okay? So your monopoly is from the complete filing date. Okay, question at the back. So, just go to the screen so the online people can read. So the question that I received now is this 3-month year to extend the acceptance period, the deadline by which it must be accepted. So it's extendable by 3 months or more. The reason why I've said 3 months or more is because the first 3 months, the Patent Office has to grant you that if you request it. Okay, so as of right, you are entitled to a further 3-month extension. So instead of 18 months, you have 21 months as of right. Any further request beyond that, you need to substantiate why you are seeking that request. Okay. So the reason why you would delay acceptance goes to where you've got corresponding applications. So remember, as I said, South African patent applications are not substantively examined. And the onus in South Africa is on the applicant to ensure that their patent is valid. So applicants delay the South African application to await examination of a counterpart application that's filed in an examining country to see whether the corresponding application is valid or if it needs to be amended. So if it is valid in another country where it is examined, they'll likely let it just go to acceptance then. Okay. If there is an objection raised by an examiner in a corresponding country where it's the same invention that was filed for, then they will amend the application and they will amend the South African application to ensure that it overcomes those objections. So that the South African application, the applicant knows that based on the opinion that they've received in examination in another country is in a valid state. So that they actually have something that is enforceable. Okay, let's go. This one.
Just, have you ever dealt with conflicting opinions? And then how would you advise it properly?
Conflicting opinions from examiners. So there are often times where there's counterpart applications and there's conflicting opinions, especially in the way America views things and the way that Europe views things. Ultimately, it's the applicant's decision as to what is the most valid for them. They know the technology. The approach that we often take is to follow the European opinion, unless they don't want to wait. Then they know that in America it's valid, so they can argue that what was validly known to them. But because South African law is so heavily, or patent law is so heavily influenced by European law, that's often the approach that is then favored. Okay, any other questions? So some countries have third-party observations or third-party objections where another party can object to it. South Africa doesn't have that. Well, we don't even have examiners at this stage. Oh, we've got, sorry, let me rephrase. We don't have examination, we have examiners. I apologize to all the examiners that are here. We do have very good examiners. Currently, we don't know in South African context because we're not. Yeah, so there's no third-party objections in South Africa currently. Yeah, the legislation will probably change, hopefully soon. Where I don't know, nobody's seen the draft apart from government. Whether it might introduce third-party objections where a member of public can, but currently you can't. Yes, sorry.
For the complete application versus the acceptance, after the 12-month or 15-month, do you have to your complete specification, all of your claims, all of your forms, everything is 100% complete? And then between that filing and the acceptance is just waiting for other applications overseas, or you just trying to get your ducks in a row in that?
Look, a lot of the requirements that you need to meet within the 18-month period from filing and acceptance. So that is getting documents signed. Sometimes it's difficult to get somebody on behalf of a company to sign those documents. You need to provide proof that the person that's applied for the application is actually entitled to apply for the application. Because remember, most applications that are filed are not filed by the inventor. Most of them are filed by a company, whether it's the employer, so somebody is employed to conduct research and to develop products. The rights mostly belong to the employer. Okay. The same with anyone at university. There's legislation that regulates the ownership of an invention for any research undertaken at the university. It's publicly funded, belongs to the university. Okay. So you need to show proof of the applicant's entitlement to the actual invention. And that can sometimes become problematic, where documents weren't signed prior to filing the application. And you must not, don't just focus on this in the South African, in the confines of South Africa. Most applications filed in South Africa are not South African applicants, they're foreigners, right? So it's pharmaceutical companies, agriculture companies, mining companies that are filing these applications and technology into the country. So they still need to comply with South African legislation. Their inventor that they've employed to conduct this research has resigned, or a relationship broke down. They don't want to sign any document to show that they've transferred their rights. So then it becomes very tricky where you've got a recalcitrant inventor to still show that the applicant is entitled. So that's why you've got this time period within which to get your ducks in a row. Okay, so it's not necessarily just to wait for corresponding application examinations, but it could also be for those reasons. Okay. Another question.
When do you work out when that application becomes open to the public? Is it only when the complete is granted, because the provisional isn't granted? Is that the date that you can say that the provisional is open to the public?
Yeah, so a provisional application is only considered open to public inspection once the complete is open to public inspection. If a provisional application is never completed, it remains a secret document. So you can even years down the line refile an application and then claim priority because it was never disclosed. Okay. Okay, so then we've got a question online. I'm sorry about the audio. I'm not too sure what else to do, Shai. Is anyone else online experiencing the same problems? It doesn't seem like it. Okay, then Luke is asking, is it 18 months from complete application filing dates or 18 months from provisional application filing date? It's from the complete filing dates. Okay, so the 18 months is calculated from the complete application filing dates. Okay, so now we've looked at it mostly in the context of a South African provisional and a South African complete, where it is a Paris Convention application. So there was a prior application filed in another country, so any other country apart from South Africa, and that is party to the Paris Convention. They also have 12 months within which to file their complete in South Africa, claiming priority. But remember, no 3-month extension available in that instance. And then it goes through the same process. It's just that distinction that I need you to remember. Yes. Yeah, so the enforceable rights from which the 20 years is calculated is from the complete application filing date. As your monopoly is from the complete filing date. When the courts look to determine whether this invention is inventive and novel, they will look at anything before the provisional filing date. Yeah. That help. Yeah. So now let's have a look at PCT and national phase applications. So similarly, you can file your provisional application in terms of Paris Convention. You have 12 months within which to file your PCT application. You don't have to file a provisional application. You can even file a complete application directly in South Africa without any claim to priority, and you still got 12 months. What you claim priority from doesn't matter. It's when you claim it and from where you claim it. Your priority must be claimed from the first filed application in respect of that invention. Whether it's a provisional or a complete doesn't matter. It's just be the first filed application in respect of that invention. You'll then file your PCT application within 12 months in terms of in terms of Paris Convention. Approximately 16 months from the priority date, you will be issued with your search reports and written opinion. So it would have undergone examination, the international application. Then within 18 months, that international application is published online, and it is open to the public to obtain the specification, to obtain the written opinions, the search reports that are issued. Everything is available online. Then, as I said, you might want to request a demand where you are filing different claims that are still based on that disclosure in the specification, but you want to focus the claims on something specific in that disclosure. You can request as an option or optionally for those claims then to also be examined. And then you will be issued with your IPRP, which is your International Preliminary Report on Patentability. Okay, so it's a top up on the search report and written opinion where you have made changes to the application, to the specification. And you want those changes then to be examined to get an opinion on that. Then you have 30 or 31 months, depending on the country's laws, as we know. In terms of South African law, we are a 31-month deadline country, and that is from the provisional application filing date. So you need to be very mindful of when these dates are calculated from, between the completes, between national phase applications. So you need to nationalize within 31 months in South Africa. Then, as was mentioned earlier, that deadline is extendable in South Africa to 34 months. So you've got a 3-month extension. The registrar does have a discretion to allow that request, okay, to grant you those additional 3 months. So it is advisable when you file the national phase application and you need this 3-month extension to provide reasons as to why you require that 3-month extension. And that is when you would enter the national phase. Once the applications enter the national phase, they undergo the same steps for foreign prosecution. So every country will then apply their laws in examining it and allowing it to grant. Okay, so there's no granted right here. Once you nationalize, it becomes the national laws of that country to then see the application through to grant. Okay, so Kuniso says that it's a little bit confusing, if I wouldn't mind re-explaining it. Everyone happy for me to go through it again? I think it can only be beneficial. So this is looking then in the instance where a client would decide to file a PCT application and to then nationalize. The benefits of doing this, we now know, is that it is cost effective because you can make a determination as to whether your invention is novel and inventive before expending money in protecting the invention in all the various countries. Because you'll have the written opinion of a good examiner with their opinion as to whether there is validity in that invention. The other is that you can also save money in terms of any amendments that need to be made, because you can effect amendments based on the international written opinion before filing, and also those amendments would then be amendments in the national country once the application is filed. So you don't need to make those amendments again. So you're saving on attorney's fees, you're saving on official fees when filing that application. It also, as we learned earlier, it provides you a bit more time because you've got 31 months within which to nationalize the application instead of 12 months. Okay, should you need more investments from potential investors, even if you want to consider making changes to the invention and the likes. So ordinarily what happens is that you would file a PCT application that claims priority within 12 months. What then happens is that the receiving office transmits the application to the International Bureau, who would then conduct, or to the searching authority, who will conduct examination to determine whether the invention is novel, whether it is inventive. And they write a well-written report, whether it is deemed to be novel and inventive. The applicant can then make a determination already. Is it worthwhile pursuing further protection in other countries? Is it worthwhile making amendments to that specification and claims in order to overcome any objections? Or am I dead in the water with this invention? If it's clear cut that this invention was already disclosed elsewhere in the world, what is the purpose of pursuing nationalization in other countries where other examiners are probably also going to object to the invention, saying that it's not novel, not inventive? So you can cut your losses early on, or you have a good opinion on which to nationalize the application. Okay, so I hope that makes it a bit clearer as to the route that you would take. So once it goes through the examination phase and the international phase, and if you do want to amend it and have those amendments examined again, because they're completely different to the amendments originally filed, then those amendments can be examined. And again, another report issued, determining whether the amended claims are now in a valid form or not. And then the applicant has to file the application in the various countries where they want to protect it to enter the national phase. So you will instruct the various attorneys across the world to say, my associates in Australia, please file PCT China 2024, 1, 2, 3, 4, 5 into Australia. And similarly, in the various countries, you would instruct your associates in the various countries to file those applications nationally. Then it goes through that country's legal framework in order to get your granted rights. Happy? Online? Everyone online there? Okay. Okay, very importantly, then you would have seen this national phase filing date equals PCT filing dates. This is very important to understand. Again, different from complete patent applications. The national filing dates in South Africa is deemed to be the international filing dates. So your 20-year monopoly for national phase application, unlike with complete applications, is not from the local South African filing dates. It's from the international filing dates. Okay, so we need to be very clear on these dates and the distinction between a national phase application filing date and a complete application filing date. Why? Renewals are calculated from what is the effective filing date. So for complete, what is the effective filing date? It's the date I lodged my complete application at the patent office, not the priority application. For national phase application, what is the filing date considered to be? PCT filing dates, okay? The PCT application filing dates. So when this application needs to be renewed is based on that day. When the 20-year monopoly runs from is from the PCT filing dates. It's not the national phase filing dates. Okay. Yeah. Any questions? So you don't need to do the demand, and you can file nationally before it goes through. I mean, you can at 22 months already file into South Africa. The only requirement is in terms of our legislation, if you want to enter the national phase earlier, if this publication hasn't yet occurred, the publication of the international application, if that hasn't yet occurred, we need to request the Patent Office to process the South African application earlier. Okay. So it's just a request, a formal request on the Form P4 document, asking that they please process the application. Because in terms of the legislation, they're supposed to wait until the 30 or 31 month deadline. The provisional application is your priority date. Okay.
In this case, was I would say after the provisional, they have 12 months to buy the complete. But that means a complete submitted together with the PCT.
It depends on which you can do that. So the question is whether you can file a complete or file a PCT. So you don't have to file a complete if you don't want. You can go through PCT and then file national phase. Or if you want quick rights, you can file a complete as well and then only nationalize in the other countries.
You know, to find out that want to make this one.
Yeah.
After you ask South Africa to proceed.
Mhm.
But then when publication comes, you see you want to amend.
If you filed a national phase in South Africa.
Is when for the
Look, in terms of the timing, that is a good question. Those amendments, because when you file the national phase application in South Africa, you don't lodge the specification. The Patent Office obtains everything from WIPO. If it was published in English, they obtain everything directly from WIPO. So based on the official records in South Africa, it will mirror the records of the PCT application. Okay, so even if those amendments were made, the problem comes in when it's a translation. So say the PCT application was filed in China and the specification is in Chinese. You have to file the English translation with the application. Okay, but now that translation doesn't include amendments made in the international phase. Then you would need to request the Patent Office to recognize those amendments, or at least alert them to it, that those amendments were, and provide the English translation for those amendments. Okay. Good question. Okay, I hope that clarifies it then for everyone. Okay, so then we're going to look at the form of the application. So in terms of Section 31, an application for patent shall be made in the prescribed manner and on the payment of the prescribed fee, and shall be accompanied by a provisional specification or a complete specification. So Section 31 makes provision for the filing of either a provisional or a complete application. Whenever the Act refers to prescribed, that means it's prescribed in the regulation. So the regulations will tell you exactly what documents need to be submitted. And then we look at Regulation 22. So an application for patent, whether it's provisional or complete, shall be made on Form P1. It must be accompanied with those documents that are set out there. So your P2 is your register page, which contains all the bibliographic details of the application. So it tells you who the applicant is, it tells you what the filing date is, it tells you what the priority application is that you're claiming priority from. It lists the inventors, the applicants, and the applicant's address. Okay, so all that information is then set out on the Form P2, and that forms part of the patent register. So when you go onto CIPC's website, that is the information that is displayed when you search for an application. Then, very importantly, is a declaration and a power of attorney on Form P3. Now, this Form P3 is very important for various reasons, because number one, it gives whoever has filed that application the power to act on the applicant's behalf, because there must be a local address for service. But But there are also various declarations within that Form P3. One of those declarations being that the applicant is not aware of any ground that could possibly invalidate the patent. So they are declaring, the applicant is declaring that they do not know of anything which can invalidate the patent. And this is where I was saying the onus in South Africa is on the applicants to ensure that the patent is in a valid form by the time it goes to grant. They are making a declaration, a legal declaration, that they are not aware of any invalidity. So if an applicant, where there's a corresponding application, knows of prior art that is actually novelty destroying, and they do nothing about it, the patent can be attacked on the basis that a false declaration was made on the Form P3. Other declarations on the Form P3 is that you stipulate who the inventors are. So you also need to be ensured that whoever was involved in inventing that invention is listed as an inventor. If you are leaving somebody off because you just don't like them, that is not advisable, okay? You don't want to give them recognition. Inventors need recognition. Another one is where the applicant is not the inventor. So you are stating that the applicant has acquired the rights to the invention from the inventors. If the applicant did not acquire those rights, then you're sitting with a false declaration again, and the patent can be revoked. Okay, so very, very important document. Then we also need an assignment or other proof of the right to the applicant to apply, which I've touched on, and we will look at that in more detail. Then if you're finding a provisional or a complete, the specification for either of those. We now know that a provisional specification doesn't need to have claims. It must just describe the invention and illustrate it by drawings, whereas a complete specification must have a set of claims. All right? Then drawings, if necessary, to exemplify the invention, as well as an abstract, so a summary of the invention, along with Form P8. The details on the Form P8 are what are published in the patent journal once it is granted after acceptance, along with the abstract and any abstract drawing. Then Section 33A, which was introduced in 14 December in 2007, when there was an amendment to the Patents Act, was that the applicant must also lodge with the registrar a statement in the prescribed manner stating whether or not the invention for which protection is claimed is based on or derived from indigenous biological resource, genetic resource, or traditional knowledge or use. The prescribed manner is on Form P26, as you can see from the amended regulation there as well. So every application in South Africa, in addition to the declarations made on Form P3, also need to be accompanied with a declaration made on Form P26, stating that the invention is either related to indigenous biological resources, genetic resources, traditional knowledge or use, or it is not. Okay, so you're declaring. If you make a false declaration on the P26, you can also attack the patent's validity and have it revoked. And I mean, this is very important from a South African context. If you think about, and I think this was why it arose, if you think about the Hoodia plant, the Hoodia plant was known to the Khoisan when they chewed on the, I believe, the roots of the plant to be an appetite suppressant. Okay, so during times of drought, when food was scarce, the Khoisan would eat on the Hoodia plant and would suppress their appetite so they didn't have these hunger pains. So there must have been a compound in there that was triggering something in the brain, suppressing this effect of the hunger pains. This compound, so you can see that is something that was traditional knowledge. It was known within the Khoisan community, right? That compound was extracted, was processed by the CSIR, patented as a diet tablet. Okay, so for weight loss, you can imagine there's such a huge market for weight loss products. A lot of money was made off of that. Did the Khoisan benefit? Should they have benefited? This was knowledge that was known to them. And this is where this form comes into play, okay? It's to prevent people that have certain knowledge from not benefiting from any intellectual property regarding that. So it is possible to obtain a patent for traditional knowledge, genetic resources, but you need to ensure that all the provisions are complied with them. And that is where you see section 33B that says that the registrar shall call upon the applicant to furnish proof in the prescribed manner as to his or her title or authority to make use of the indigenous biological resource, genetic resource, traditional knowledge or use. If an applicant lodges a statement that acknowledges that the invention for which protection is claimed is based on or derived from indigenous biological material, etc., etc. Okay, so if you did use traditional knowledge, use genetic resources, you need to then provide proof of the authority that you are actually entitled to file this application and that there is some benefit going back to that community. I mean, it's very difficult to make these determinations. What proof is considered? You need to look at Regulation 33B. So you'd need to provide either a copy of the permit issued in terms of Chapter 7 of NEMBA, or proof that prior consent was obtained, again, looking at NEMBA. I'm not going to go into the detail of this, but just know that there are these additional requirements that need to be complied with if it is related to traditional knowledge and use and genetic resources. There must be proof of a material transfer agreement, proof of a benefit sharing agreement, that the community will benefit from any reward garnered from exploiting the invention, or proof of co-ownership of the invention. Alternatively, any other proof to the satisfaction of the registrar. Yes.
To know the of NEMBA.
You don't need to know the provisions of NEMBA for the exam, but if I do ask what proof would the registrar consider acceptable in granting a patent where it is related to indigenous biological material, then you should be able to just list some of those points for me. Okay. Sorry, I think I've... Okay, so then going back to the proof of the assignments or the applicant's entitlement. The Regulation 23 of the Patent Act provides that, or patent regulations, is that the application must be accompanied with an assignment. An assignment is a written contractual agreement between one party and another, where they are transferring the rights in writing to the applicant. So an assignment or other proof to the satisfaction of the registrar of the applicant's right to claim priority. So that is an assignment of the rights, the priority rights. As I said, most applications that are filed are not filed by inventors. The inventor is ordinarily the first right holder of the invention. They've created it. They're the author of that invention. The rights ordinarily sit with them. Okay. So they would need to show, if it is a company or another party that is filing that application that is going to be granted this right by the government, that that party is entitled to the application. So that is either they have signed a contract, the deed of assignment, assigning the rights from the inventor to another party, or it could be by way of employment. So was there an assignment in terms of their contractual obligations in terms of their employment contracts. And I can guarantee you, if you look at your employment contracts, there will be some provision in there that states that any IP developed in the course and scope of your employment within my employment with company Spoor & Fisher belongs to Spoor & Fisher, right? As an example. Then there's also the transfer of the invention by operation of law. By operation of law, I mean where there's a statutory requirement that the rights belong to somebody else. So that would be in the instance of universities where there is publicly funded money going into research and development. There, it's the IKS, I think, Intellectual Property Rights Act, sorry, that provides for the university, the organization that is publicly funded to acquire those rights. So if you are students at a university conducting research for your PhD, whatever comes out of that research, any intellectual property, belongs to the university. Similarly with the CSI arm. There are also countries that have specific legislation. So if you look at the UK Patents Act, Section 9 of the UK Patents Act states, any invention created in employment of the third party during the course and scope of employment belongs to the applicant. So it is legislated, right? So those rights automatically belong to the third party that's applying for the application. But we still require proof that those rights vest with the applicant, even if it's automatic by operation of law. So what do you do to overcome this? Because there's not going to be a deed of assignment. Okay. So what you'll do is you'll get the inventor to sign a document that confirms that their rights have transferred. Okay? And that will be sufficient proof for the registrar, or any other proof that satisfies the registrar's requirements, that they are happy, that the registrar is happy that those rights have transferred. Your employment contract, you could submit that as proof that shows that there's an assignment in terms of your employment contract. You can make a declaration in the Form P3 that expressly states on which provisions you're relying in terms of an operation of law assignment. The registrar has confirmed in a practice directive that that is also acceptable, where it is by virtue of an operation of law, but you need to specify in your declaration exactly what that provision is. And there are various ways to provide proof, but those are just some examples that I'm going to be working, that I've explained to you now. Then you can have a look at Regulation 24, Regulation 25 in your own time. Again, Regulation 30 or Section 30, subsection 2. As I said, there must be a local address for service in South Africa, which is provided for in the Form P3. Okay, minimum filing requirements. So in order to obtain your filing dates, certain minimum requirements need to be met. Guys, can I tell you this happens a lot in practice, where you have a client that all of a sudden realizes, shit, I have something, excuse my language, they have something that's frustrating because it happened. I'm presenting at a trade exhibition at 12 o'clock today. I haven't even considered obtaining patent protection where there is an invention. So you're not going to have everything in order to file that application. So this is where this provision kicks in. You need to be able to obtain that filing date so that I can today exhibit at this trade exhibition and disclose my invention. And this happens quite regularly. So in order to do that, you must pay your official fee, so your 590 Rand for a complete application. It's even less for provisional application, like 200 and something, to file your provisional application at the patent office. Then the application form must also be signed either by the applicant or his agent. So the firm that represents the client, they must sign the Form P1 and also include as much information as they can that is required in the Form P1. Then also a copy of the specification it is possible, if you're not able to provide the specification, to file it within 14 days from the date of application. So even that is done away with. And then also drawings. So where it's a convention application, the specification can still be late lodged within 14 days of filing the application. If an application is filed in another country that is not an official language of South Africa, you need to provide a translation into one of the official languages. So if it's an application that comes from China that is in Chinese, you need to file a translation in one of the official languages in South Africa. And that you need to do within 3 months. And that is for a convention application. So for a complete application, you have 3 months. If it's a national phase application, you have 6 months within which to file that translation. Okay. Then we can rush through section 43E. These were amendments to the Act once we adopted the PCT that then allowed for national phase applications, which again just prescribes what requirements need to be complied with in order to nationalize that application. For a national phase application, the application document is different. It's not a P1, it's a form P25. How's everyone doing? Tired? It's okay.
Supposed to know regulations that in 5 sectors or just supposed for the possible.
So the regulations that you need to know are the regulations that are in the slide. I don't expect you to know all the regulations. Those that are in the slide are the most important. Those that I've brushed over now, sorry, lost kick of a dying horse. Sorry. Those are the most important. Guys, I'm really not going to focus too much on the regulations. Okay, where it is critical to know, and that goes to the example where I said, I'll provide you with the patent's details and ask you what dates. Even in those instances, I'm not going to ask you what regulations rely on. Okay, but you need to know the regulation provides. The acceptance must be published within 3 months. So don't be too fixated on exactly regulation 63 subsection 2 provides for this. Okay. But those regulations that I have set out in here are the ones that you should know. Okay, we are now on slide 58. We have about halfway there. Okay. Let's see. I'm debating whether to continue. Okay, this section is still quite long. You want to call it a day? Up tomorrow? Yeah. So either we continue for another half an hour, and then hopefully we can finish a little bit earlier tomorrow, or I can't guarantee that we'll finish earlier tomorrow. Okay, I think let's have a quick 10-minute comfort break. We'll return at 3:30.
I have a question. I think it's a silly question. I don't know. So you're in an industry that is ever changing, ever developing, and it's a race to kind of see who's the fastest to innovate something or whatever. And you have a patent that you've got a registration for whatever the case may be. Now you are the next person
to invent something to even make your product or whatever process even better. Is there a way to kind of amend your existing patent? You have to go through the whole process again of filing a new application.
Yeah, so we're actually going to get to that still. So where there is an improvement on the technology we've already filed, you can lodge a request for that to be considered
Okay.
part of the application.
So just
So there
thinking
is,
in terms of time and cost,
yeah.
not having to go through that whole process again.
But the thing is, that's only in a South African context. So what happens overseas where you might have a market,
Yeah.
it might be different. But in terms of South Africa, you can.
Okay.
Yeah, but we'll get to that. That's
Okay.
part of
I
it.
was just wondering because I just thought, if you already have rights,
Yeah.
kind of asked to.
If it's related, it's an improvement or modification of what you've already lodged.
and
you can.
are
The proprietor, yeah, then you can.
okay. Oh, that's interesting. Thank you.
started around these ones. Farther, even though they like a control of this one, we just say, "Oh, this is one." They want to try to.
Okay, everyone, it's 3:30. I think let's continue for the last 30 minutes of the day. So we're going to have a look at section 31, which states from where you can claim priority from. It's a lot of words. I don't want you to get confused by it, but it is quite straightforward. So it basically states that you can claim priority from a prior application accompanied by provisional specification. So where you filed a provisional application, you can claim priority from that. Straightforward. Secondly, it says you can claim priority from a prior application accompanied by a complete specification, and there's no claim, and that doesn't itself claim priority. So if a complete was filed in the first instance that doesn't claim any priority, then you can claim that provisional application's filing date, even though it is a complete application and not a provisional application. Then for an application in a convention country, you can claim priority. So the first two relate specifically to it being a South African provisional or South African complete. But then it also goes on to say that you can claim priority from a convention application. So this is the importation of the Paris Convention provisions into the Act. It says that you can claim priority from an application convention country, provided that the prior application was lodged not earlier than 1 year before, or on payment of the prescribed fee not earlier than 15 months before the date of application claiming priority. So this states that you can only claim priority within 12 months, or if it's South African application within 15 months. Again, in subsection 2, the application in the convention country was lodged not earlier than 1 year before the convention application and was the first application in any convention application. So similarity drawn between 1 and 2, or the distinction being that 1 relates to South African application, where it's a South African provisional that you can claim in 15 months or 12 months or 15 months, but where it claims priority from a convention country, then it must be claimed within 12 months. Okay. And the applicant in the application claiming priority is the proprietor of the prior application or has acquired the right to claim priority in the Republic. So the proprietor of the South African application must be the same as the proprietor of the application in the convention country. When I refer to convention country, that means a country that is part to the Paris Convention. Okay, it's a country that is a party to, that has ratified the Paris Convention. The applicants must be the same. If the applicants are not the same between the two applications, the South African applicant must show that they have acquired the rights from the applicants of the priority application from which you're claiming priority from. Okay, does that make sense? So as an example, you have a large corporation. Let's take Unilever as an example. Unilever has multiple companies or in various countries, right? So you've got Unilever in the Netherlands, you've got Unilever in England, you've got Unilever in America, known as Knopco. Overall, same company, different companies in those countries. So shareholding be the same, but they are registered as separate companies. The one does business in South Africa, so the Dutch company does business in South Africa, but the application was filed in the American company's name, the priority application. So you need to show that the South African company, or the Dutch one, claims priority, that they've obtained the right to claim their priority from the US company. So it's just showing that there is this right to claim priority from one applicant and another. We also know that the application from which priority is claimed must be the first application for the subject matter in that application. You must claim priority from the first application in respect of that invention in order for the priority claim to be valid. Now, this becomes problematic in some countries, particularly in the United States, as an example, because you have an issue which we refer to in practice as the Benz issue, where in the US they filed a provisional application. They've then completed that application in the US. They then wish to file an application in South Africa. But the deadline from the first filed US application has already passed. But they claim priority then from the US complete application. Okay, it's still within the 12 months. But that complete application is not necessarily the first filed application. I hope I haven't lost anyone. Can I draw on the board? I'm hoping a guide online can see it as well. So let's say there's an invention that arises from the US. Okay, it was invented in the US, it's a US company. They file US prompt for this invention. Okay, that is the first filed. Guys, I don't know what to do. Hopefully that's better. Your cap is off. Okay, can we see that now? No. I don't know how to do that. Okay, guys, I'll take a picture of this and then circulate it. So they filed the US PROV for that invention. That is the first filed application for that invention. Then, within 12 months, they filed the US complete. But now they also want to protect it in South Africa. But more than 12 months has passed from which to claim the South African application. Because there's already 12 months that has passed. So in order to claim priority from that, you're not able to. In terms of Paris Convention, you've only got 12 months. So what they will do is they will instead claim priority from the US complete application. But is the US complete the first application in respect of that invention? It is not. Okay. The US PROV is the first application in respect of that invention. Then you're sitting with the problem because their priority claim is invalid. They're also stating on their Form P3 that their claim to priority is the first invention in respect, is the first application in respect of that invention. So their declaration on the Form P3 is also incorrect. So this renders it a Benz issue. So this is a court case, which is the Benz case, where this was held to be an invalid priority claim. This, where it's not the first application in respect of that invention. Okay, that makes sense to everyone. What is permissible is if the US provisional discloses integer A and integer B. That's the novelty that exists in this application. But they have developed the invention further by the time they file the US complete. They've added a new integer C. So A and B are there in both. C is not. But C is novel. Do you think there's an issue then or not? There's no issue. They're validly claiming priority from the first disclosure in respect of that invention, provided the South African application also includes A, B, and C. Okay. So I hope that helps. Sorry for the online guys. Yes.
Why is it that for A and B haven't changed, but they can claim priority? Or the priority date for A and B?
Because now the invention isn't A and B, it's A, B, and C. They've added a novel integer into this complete.
Is there any argument for future court cases where they say A and B aren't novel anymore, so you can only claim priority for C?
No, you only need one novel integer. There only needs to be one new feature that gives you novelty. So in this case, that claim is completely valid. Okay. So that's basically what section 31(2) says, that you must claim from the first application. It is possible to withdraw a prior application. So where you have filed an application, you want to claim priority from a different application. That first filed application must have been withdrawn, that you're not claiming any priority from those rights, or that there are any other rights outstanding. So where you've tried to complete it and it's still in the process of being completed. But you can have a look at that section then on your own time. Then what does a specification need to comprise? Section 32 says that every specification that accompanies an application must indicate whether it's a provisional or complete. Must also commence with the title, so you must have the title of the invention, part that precedes the specification's description. Provisional specification must fairly describe the invention. As I said, there are no claims needed there. For a complete specification, you must also have the abstract accompanying the application. It must sufficiently describe, ascertain, and where necessary, illustrate or exemplify the invention and the manner in which it is to be performed in order to enable the invention to be performed by persons skilled in the art of such invention. So it must be an enabling disclosure. It must have sufficiency. If you do not sufficiently describe the invention for somebody that is skilled in that technology to be able to exercise it, then the patent can be revoked. So it's very important for the patent attorney that is drafting that specification to ensure that they have all the information from the inventor on how to perform this invention, so that they can write it in a manner in which a third party that is skilled in that technology, in that art, is able to perform it themselves. If they are unable to, it's considered to be insufficient, and the patent can be revoked. Then, importantly, it must end with the claims that define the invention for which protection is claimed. And the claims are what the courts look to when determining what the scope of protection is and whether your patent is being infringed. The claim shall relate to a single invention, shall be clear, and shall be fairly based on the matter disclosed in the specification. Okay? That's the only guidance we have in terms of the way we should draft claims. In addition to, anyone, what case did we look at? Ensign Bickford case that tells us this is the way you must do for-use claims, this is the way you must do second medical use, which is Swiss type claim format. Other than that, it's your discretion, but practice has evolved and people stick to specific ways in which these claims are drafted. But they must relate to a single invention, they must be clear, so there mustn't be any uncertainty as to what it is that you're claiming, and it must be fairly based on matter disclosed in the specification. So whatever it is that you are putting into your claim, you must have disclosed it prior in the specification. So in the description, there must be the same integer disclosed. Okay, so there must be fair basis for that claimed subject matter in the disclosure. Interestingly, if an application or specification claims more than one invention, there's no recourse to a third party. So you can't revoke the patent because it consists of more than one invention. It's a bit of a contradiction, okay? But we'll get to that a bit later on when we look at divisional applications, okay? So this is where you would have a unity of invention objection by an examiner, where they find that your claims claim more than one invention. So let's think of a pharmaceutical product again. There's a method of manufacturing that invention that is new. So you're claiming the method of manufacturing that pharmaceutical. You're also claiming that composition itself. Those are two separate inventions that you're claiming. Okay, they're all comprised in the same specification. So in terms of these provisions, that's not really permitted. And that's when examiner will raise a unity of invention objection. In other countries where examination takes place, not in South Africa. Okay, then you can have a look at Regulation 28. You can also have a look at Regulation 67. Then Section 33 provides that if you are claiming priority from an earlier filed application, it must be fairly based. So your disclosure in your earlier filed application should be related. It should be fairly based, your complete application. There must be fair basis for it. So in determining whether invention claimed in the application is fairly based on the matter disclosed in the prior application, regard shall be had to the disclosure contained in all documents lodged at the same time in support of that application. So it just says what do you consider for fair basis when determining whether that priority claim is valid. Okay, then sections 33, subsections 3, 4, and 6 go on so that you can claim more than one priority date. So that is if you've filed multiple applications at the same time in different countries, or if we have a look at the US example, where you filed the US Prov, you filed the US Complete, but you are still within the 12-month period to claim the US Provisional, you are able to claim both priorities for A, for the Prov, and B, for the Complete, provided that it is within 12 months. You can have multiple priority claims. Guys, I think that should bring us to the end of today before we move on to section 38. So with that, thank you, everyone. Are there any questions before we end for the day? Okay. Let's see everyone's fading fast, including me. Don't feel guilty. I hope I haven't scared you off, and I hope that you'll be back tomorrow. But thank you, everyone. Then we'll pick up again tomorrow. Thanks, everyone online. Thanks. Hi.